Swayam Prabha. Digital India. Educated India.
Hello again. Taking forward our discussion regarding TTBER principles and the safe harbor provisions for various technology transfer agreements, let's discuss something about the agreements falling outside the block exemption. So, as we discussed, the TTBER provisions have given certain technology transfer agreements for the technologies or particularly intellectual property related technologies, where if the market shares are less than 20% for the competitors or more than 30% for the individual non-competitors, then they may get a safe harbor provision. But what if there are certain agreements which does not fall in the criteria of this safe harbor or the TTBER block exemptions. So, particularly those kind of agreements where either the parties have a larger market share or when the agreement is between more than two parties. So, in those cases the TTBER principles are not directly involved. However, the technology transfer guidelines has provided various guidelines regarding those kind of agreement. So, in general, when the agreement is between two or more non-competing entities, then the European Commission, there is a less likely chance that the European Commission looks into the various anti-competitive effect for those kind of agreement. But when the agreement is between the competitors, means those who are involved in producing same kind of product or technology and have the IP in the same kind of technology, then there may be certain chances under which the anti-competitive factor can be raised. So, in the technology transfer guideline, it has directly stated that the article 101 is unlikely to be infringed where there are 4 or more independently controlled technologies in addition to the technologies controlled by the parties to the agreement that may be substitutable for the licensed technology at a comparable cost to other users. That means, when there is agreement between two or more parties and the parties are in control of 4 or more independent technologies, then there is a less likely chance that there will be an anti-competitive effect. And here the term the substitutable licensed technology means, even though the competitors are having certain technologies that may be substitutable by any other related technologies. So, there is a less chance that the agreement will lead to certain anti-competitive thing. So, that has been made clear in the technology transfer agreement. And further, while assessing the technologies, it is definitely taken into account that whether the technology are sufficiently whether the technologies are sufficiently substitutable, means the relative commercial strength of the technology in question must be taken into account. Means while looking into this kind of agreement, the European Commission generally assess that what is the strength of this technology, means is this technology is really substitutable by any related or any alternative is available for that technology or not. If certain alternatives are available, then there is less chance of anti-competitive effects. Now, as I mentioned, when the agreement is between the non-competitors, then the European Commission does not look into unless there is certain specific query regarding that. But when the agreement is between the competitors, the EC looks into the agreement into the following factors. First, it looks into the nature of the agreement and what is the market position of the parties involved. What is the market positions of the competitor, even though they are not involved directly in the technology transfer agreement, the other competitors, what is their market position, and what is the market position of this buyers of this licensed product, and whether there is any existence of or any like what is the extent of the entry barrier for the new technologies they are creating, and the maturity of the market. These individual factors are looked into greater details to understand the anti-competitive effect of the agreement. For example, nature of the agreement, whether it is a exclusive agreement, whether there is any reciprocal clause involved in it, whether there is any non-compete clause associated with it, which may further inhibit the development of the new technology, or which will may lead to price fixing of the product. Similarly, market position of the parties means if the parties involved have a greater share or are having a larger market share, then there is high chances that will lead to a high competitive thing. And again market position of the buyers means if the buyers are willing to pay some such amount of money to buy the technology. So, it also depends on the buyer, the purchasing powers of the buyer, or the acceptability of the technology from the buyer's end, and whether there is any entry barrier, they are creating any entry barrier or not. Means if there is any reciprocal arrangement by which the new technology are not being taken outside, or the innovation is hampered, then also it is a sort of anti-competitive thing. Also, the maturity of the market means whether the technology is such that the people are really not willing to give up the technology, or is there any acceptability for a newer technology in that domain. So, maturity of the market, greater is the maturity, then greater will be the market share of the competitors. So, all these factors are taken into account to look into this technology transfer agreement to find out whether it is abusing or whether it is going against the provisions of Article 101 subsection 1 or not. So, talking about all this, so there are the certain negative effects of the restrictive license agreements are there. So, the negative effects on the competition on the market that may result from this kind of restrictive technology transfer agreement may include: first, the reduction of inter-technology competition between the companies operating on a technology market or on a market for the products incorporating those kind of technologies which is in question. So, that may lead to facilitation of the collusion, both explicit and tacit. Means if there is already certain restrictive provision mentioned in this agreement. So, as I was mentioning earlier, so no new product or no new technology can be can come to the market. There is already a barrier, means only or the licensee already if the licensee has given a clause where the licensor cannot do R&D on the licensed technology. In that case, it becomes it reduces this technology competition, and only the current IP is IP which is associated in the technology licensing agreement is being given priority. Also, it may lead to foreclosure of the competitors by raising their costs, restricting their access to the essential inputs, or otherwise raising the barriers to the entry. So, again this kind of restriction in the agreements may lead to foreclosure of the competition. So, no new technology, and that may lead to price fixing and increase their cost. And since third party licensing is also not allowed, then also it may high chances there the product price may increase, and it may lead to like access to the essential input, because no third party is involved. So, now sub licensing or involvement of the other parties are allowed as per the agreement's clause. Then it is a kind of restriction to the essential inputs, and that may lead to raising barriers to the entry. Like from other geographical location, it is possible that the technology may not go to the other relevant product relevant geographical location. Then thirdly, it may lead to reduction of intra-technology competition between the undertakings that produce the products on the basis of the same technology. So, so this is the primary negative effects which has been which may come out as a result of this restriction in the agreement. And in general, there are like in the technology transfer agreement, particularly dealing with the IP, there are certain restrictive provisions always, but again there are the guideline lists out certain restrictive condition which is generally found in the technology transfer agreement, and those are not treated as the restrictive in nature. Those are as follows. First, the confidentiality obligations. In most of the IP related licensing agreements, it is the confidentiality clause is one of the very important clause, where the licensor are not allowed to disclose or open up about the technology which they are licensing. Then the obligations on the licensees not to sub-license. So, without the permission of the licensee, the licensor, the licensee cannot sub-license its sub-license the technologies associated with the agreement. Third, obligations not to use the licensed technology after the expiry of the agreement, provided that the licensed technology remain valid and in force. So, in general, because the patent rights or the other intellectual property rights are for a limited durations. So, in those cases, the IP agreements are also generally done for a limited period of time, and so there are obligation on the party of the licensee to not to use the licensed intellectual property thing after certain period of the time. And there are certain clauses also but when these clause extends not to use or not to further improve upon that thing, that may lead to anti-competitive, but per se the obligation not to use the IP after the duration which was mentioned in the technology transfer agreement is not restrictive in nature. Then there is also obligations to assist the licensor in enforcing the licensed intellectual property rights are there, that is also not restrictive in nature. Then obligations to pay minimum royalties or to produce minimum quantity of the products incorporating the licensed technology. Sometimes the licensee puts forward an obligations where the licensee can only produce a limited quantity of the material or product in question, and for a limited or in a limited geographical location, but in case of a high end technology, that becomes sometimes essential to restrict it in a time frame or in a geographical location. So, depending on the merit of the cases, in majority of the cases it is not considered as an restrictive in nature. Then there is also obligations to use the licensor's trademark or indicate the name of the licensor on the product. So, as quite obvious, as the licensee is giving its technology to the licensor, so the licensor is giving the technology to the licensee. So, it is desirable on the part of the licensor to put his trademark or name or logo on the product which is manufactured. So, in majority of the cases that happens, unless and until the licensee does not have the licensor does not have that capability to produce that product capability or the infrastructure to produce the product involving those IP, unless a scientist or researchers has developed certain technology, they may give to some company. So, there it may not be necessary, but when the bigger companies are in possession of certain intellectual property right, in general they insist that their trademarks or names should be on the product. So, these 6 conditions in general are not considered as restrictive in nature, unless it is extendable to other some other related clauses. So, going forward with these restriction clauses, so basically the technology transfer guideline has also specified regarding the various restriction clauses which may arise in a technology transfer agreement. For example, the restrictions in the licensing agreement, the royalty or the non-compete agreement. So, in general, for all the IP related technology transfer agreements, the royalty is decided by the licensor, and maybe it in the form of a lump sum payment or maybe in the installments. So, that in general does not attract the European Commission's eye on the kind of agreement. But when it extends to certain other non-compete agreements, like not to by restricting them to again not to use any third party technology along with their technology, or they should not go into R&D of that kind of technology for certain period of time. So, when that kind of clauses are associated with this thing, then it may raise the question of violating Article 101. And other clauses related to the exclusive licensing and the sales restrictions which are generally assessed are the field of use restriction, captive use restriction, the tying agreement, settlement agreement, and the various patent pools. Field of use restriction means when there is a technology which may be used in manufacturing of 2 or more than 2 products. For example, there is a mold which may design a glass bottle or which may design a plastic bottle, but when there is the technology transfer agreement, so the licensee is can only prepare the plastic bottle, not the glass bottle. So means the technology can be used for a particular thing. So in that case, this is known as the field of use technical field use restriction. So that is also okay, but sometimes again like if the technology is so crucial for development of the certain other products also, and the licensee is not allowed to use the technology which he is already producing, and then that may raise the question of violating 101. Then there is captive use restriction, means again like the licensor gives certain timeline in which only he can prepare, or he provides the geographical location for which only the product can be prepared, or he lists out the customer to which he can sell the product. Then like it is a kind of captive use restriction, and in those cases also sometimes like the EC European Commission looks into detail whether to find out whether it is abuse like whether it is in violation of article 101 or not. Then there is a tying agreement, like when the licensor is in a strong position, it has a high market share. So it may possible that it is going for like bundling of the things, like with when somebody is wanting to license a single technology, the licensor may ask or may tie up certain related products along with it, like you may take the raw material along with the technology or any sort like that. So that that may happen, but it is generally mostly seen when the licensor is having a high market share and there is no alternative is available for them. So in those cases it may lead to anti-competitive practices. Then there are settlement agreements. Specifically, these kind of agreements are seen in the generic pharmaceutical industries, where like the pay for delay tactics or the various co-promotional agreements are there, which delays the entry of a new product or maybe a generic product or a cheaper product to the market, and the the innovator company retains its market exclusivity. So, but again that hampers the competition, and the prices are made high. So, those are also those cases may lead to anti-competitive behavior. And there are patent pools. So, again patent pools are like a single platform where numerous technologies can be found or licensed. So, in many ways this is very essential and very helpful, but sometimes also that may lead to anti-competitive behaviors. So, we would look particularly these last two things, settlement agreement and patent pools, and how the technology transfer the guideline on the technology transfer agreements have given certain emphasis on these two. So, the settlement agreements are specifically they are considered as measures by which we can two parties can resolve the dispute or many licensing issue. So, per se the settlement agreements are not anti-competitive, because like the out of court settlement. So, it is a basically mutual consent between the two companies, two or more party which may be involved. So, per se those are not anti-competitive, but there might be certain individual terms which may be caught under the subsection 1 of article 101. So, the technology transfer guideline particularly addresses three major issues. First, the pay for delay restrictions. Second, the cross licensing. Third, the non-challenge clause. So, the pay for delay restriction, like as I said, like particularly in the case of generic pharmaceuticals, like some payments or lump sum money is generally given to restrict the entry of a new product or a generic product to the market. And in the cross licensing means only the two parties in questions, like they should they cross license the technology with each other, and no third party is allowed to license the technology or give the technology. So, what happens, there is a limitation in the technology development, the innovation is hampered, and that is also considered as an anti-competitive behavior. And there is non-challenge clause. Sometimes the like the IP which is in question or which is there in a technology transfer agreement is wrongfully given based on certain misleading fact. So, the licensor generally puts a clause saying like the licensee cannot challenge that IP in question. So, that is like again against the European competition policy, and this kind of thing is considered as anti-competitive behavior. So, these three like pay for delay restrictions, cross licensing and non-challenge clauses have been dealt elaborately in the technology transfer guidelines. The Commissions considers that the so called pay for delay type of settlement agreement in general do not involve the transfer of technology, but these are based on the value transfer from one party in return for a limitation on the entry or expansion of the market on the other party. So, in generally it is not the technology transfer of technology per se, but it is just a payment method, like payment, lump sum payment, which is made to stop the expansion of the market or entry of the product. So, the guideline notes that if the parties to such settlement agreement are actual or potential competitors and there was a significant value transfer from the licensor to the licensee, the Commission will be particularly attentive to the risk of market allocation and market sharing. So, basically the pay for delay tactics is more like and comes under more scrutiny when it is between the two competitors, potential competitors, means when the two parties are in possession of nearly similar kind of technology. So, then only this kind of thing is may create an anti-competitive effect or affect the market structure. There are various cases like which has led to inclusion of these guidelines in the latest TTBER guideline, which we will be discussing one by one. For example, this Lundbeck decision, Servier, Johnson and Johnson and Novartis case, like which all of these cases has raised the concern for the pay for delay. And particularly in the Lundbeck decision, the General Court has confirmed the Commission's approach in the year 2016, and it has stated that entering into an agreement with an actual or potential competitor to delay entry into a market in exchange for a monetary payment is a by object infringement. So, there can be two types of infringement, by object or by effect, in effect. So, by object means if any agreement per se, like the object of the agreement is to stop the entry of a product or expansion of the market, then by object it is like it will be considered to be an infringement of article 101, and if certain clauses may lead to certain results that is affecting the market structure, then that is kind of in effect infringement. And this guidelines also referred in the section to the 2012 ruling case of AstraZeneca, where it has been noted that the non-challenge clauses in the settlement agreements can be problematic where the IPR is granted following the provision of incorrect or misleading information. So, coming to this Lundbeck decision, so the Lundbeck subsidiary like company of Netherlands, like it was one of the pharmaceutical company, so the proceeding against the company was initiated in 2010, and particularly certain unilateral practices or the agreements with the object or the effect of preventing the delay of generic citalopram citalopram into the market, particularly in the European market, was in question. And they suspected that the agreement or this practice is infringement of article 101 and or article 102. Also, it infringes article 53 and 54 of the EEA, European Economic Area Agreement. So, basically this citalopram was a blockbuster antidepressant medicine, and it was the Lundbeck's best selling product. So, Lundbeck held a number of patents on this citalopram antidepressant medicine, but when the main patent on this citalopram expired, so Lundbeck only had few ancillary patents, like one of the patents were regarding the preparation of the crystallized salt form of this medicine. So, these ancillary patents were not that effective in holding this market, holding stronger position for Lundbeck. So, Lundbeck, like it was becoming difficult for Lundbeck to stop the other generic manufacturers to produce the generic citalopram, which will be available at the cheaper cost. But so, during that time, what happened, the Lundbeck approached the other potential generic competitors, and the generic competitors agreed to enter into an agreement with the Lundbeck in 2002 for not entering into the market in return of a substantial payment and other inducement from the Lundbeck. Means the Lundbeck has given certain lump sum amount of money in terms of millions of euros to the other potential generic manufacturers and stopped them to enter into the generic segment of citalopram. And also Lundbeck offered guaranteed profits in the distribution agreements, like so what has happened, Lundbeck also bought back like all these stocks of this generic citalopram from the generic manufacturer and destroyed it, and it offered the guaranteed profits like to them in the distributed agreement. And like so, in both the way, by destroying the generic medicine as well as by stopping the generic manufacturer from directly entering into the market by paying the lump sum amount, Lundbeck has successfully retained its market position, and so that came to the eyes of European Commission. And finally, the European Commission has imposed a fine of 93.8 millions on this Danish pharmaceutical company, and other and the generic pharmaceutical companies are also fined nearly 52 million euros. So, the notable generic companies were this Alpharma, then Merck, then Generics UK, Arrow, and also Ranbaxy. So, all these companies, means both the parties were fined because both the parties readily agreed to enter into those kind of anti-competitive agreements. So, the European Commission has fined them, and this was the decision. So, after those cases, like the European Commission's, particularly the pharmaceutical sector, like the Commission has different departments which look into the various cases particular to the technology. So, the Commission's pharmaceutical sector inquiry has identified that the competition between the originator company and the generic company is not a very simple and straight competition. And so, it has to be scrutinized very carefully to understand whether the behavior are anti-competitive or not. So, in this context, the Commission has started looking into the various instruments in which the originator company or the innovator company resorts in their strategy to confront the entry of the generic drugs. And those strategies are particularly the patenting strategies, such as the patent clusters, like having more than one patents in a particular drug segment or drug molecule per se. Then dispute and litigation against the potential generic competition by filing or by having by initiating certain disputes or litigation against the potential competitor also delays the entry of the generic product into the market. Then patent settlement with the generic company, as this case was, and the various interventions and launch on the following products. So, all these four major tactics from the innovator companies are looked into by the European Commission to see whether these behaviors are anti-competitive or not. So, in the final decision, the Commission has found that the agreements by the Lundbeck constituted restriction of competition by object, and which is in breach of the prohibition of anti-competitive agreements under Article 101 of TFEU. And the Commission gave a theory of harm, and this theory of harm can be summarized in 3 points. First, the Lundbeck and the generic undertakings were at least potential competitors. Means Lundbeck has the technology, and as the technology has expired or the patent has expired, the generic manufacturer had also the potential to enter into the same domain. So, they are the potential competitors. Second, the generic undertakings committed in the agreements to limit for the duration of the agreement and their independent efforts to enter one or more European Economic Area market with their generic product. So, with that agreement they agreed to not to enter into the market, which has like stopped the introduction of the cheaper product into the market. Third, the agreement related to the transfer of value from the originator undertaking, which reduced substantially the incentive of the generic undertaking to pursue independently its effort to enter into the European market with a generic product. So, like by getting without supplying the product to the market, the generic companies were getting the money. So, that is also kind of like they did the generic companies did not give any independent effort to enter into the European market. So, these are these theories of harm which the European Commission has come out with this decision. So, this is one of these landmark decision where this pay for delay tactics is considered to be in violation of Article 101. There are two more cases we will just discuss, and another important case in this direction was this Johnson & Johnson and Novartis case. So, the Janssen Silag, which is a subsidiary of Johnson & Johnson, was supplying the painkiller drug which is known as fentanyl in Netherlands, and it concluded a co-promotion agreement with the generic competitor Sandoz, which is a Novartis subsidiary, in 2005. So, what has happened during that time in 2005, there was no regulatory barriers to develop and market the generic versions of this fentanyl patches, and therefore, the Sandoz was free to enter into the Dutch market. However, the Janssen and Silag offered certain monthly payments to Sandoz, so that no generic product like this fentanyl patches can be launched by Sandoz in Dutch market. So, the Sandoz consequently Sandoz abstained from entering into the market with the generic fentanyl, and the duration of the agreement from July 2005 to 2006, like it may had proceeded further, but what happened, like in December 2006 another third party was about to launch this generic fentanyl. So, during that time Sandoz raised his objection, and so this came into the eyes of the European Commission, and finally like it has come to the European Commission found that this kind of co-promotional agreement between Janssen and Sandoz has delayed the entry of the generic medicine for 17 months, and the price of the fentanyl patches has been kept artificially high in the markets of the Netherlands. And during this time, from June to the July 2006, Janssen Silag has paid approximately 5 million euros to Sandoz in a monthly installment for this undefined agreement, and it has stopped Sandoz from entering into the market, as well as for stopped Sandoz from carrying out any promotional activities. And finally, in 2010 the European Commission concluded that this agreement is a restriction of Article 101, and both Johnson and this Novartis were fined heavily, and like more than 10 million euros, like Johnson has been fined more than 10 million euros, and nearly 5.5 million euro was fined on Sandoz. One of the in the same direction, like I told you, like this is the one of the important what you say is a method by which the innovator pharmaceutical company stops the entry of the generic pharmaceutical companies. So, in the same line, one of the important cases was AstraZeneca, where not only this pay for delay tactics was associated, or as well as this non-challenge clause or misleading ground by which it has tried to extend its IP rights was questioned. So, basically AstraZeneca has a blockbuster product called Losec, which is a omeprazole based medicine used for the treatment of the gastrointestinal conditions. which is linked with the hyperacidity, and it is a kind of new technology that time which was proactively which involved a proton pump kind of thing. In 1999, the generics company from UK and the Scandinavian pharmaceuticals like generic AB complained to the commission regarding the AstraZeneca's conduct, and they said that AstraZeneca's conduct is aimed at preventing the generic manufacturers from introducing the generic version of omeprazole in a number of markets of the European Economic Area. So, the commission found that the AstraZeneca's conduct were infringing, there are two kinds of abuse of dominant position, and they were infringing the article 102, that is article 82 of European Commission, and article 54 as well. The first abuse are again classified into two types. In the first case, the first abuse was concerned when this AstraZeneca has made representation in 1993 where instructions were sent to the patent agents through whom the supplementary protection certificate application were filed. So, basically there is a provision called supplementary protection certificate by which the patent life can be extended for 5 more years, because in case of what happens in case of biologic drug molecules, while getting marketing authorization takes a long period of time. So, to get effective benefit from the intellectual property, so there are provisions by which the patent rights can be extended to certain period of time, and that can be achieved by the supplementary protection certificate. So, it has been found that on misleading grounds the AstraZeneca has made representation for getting the supplementary protection certificate, and subsequently it has made this representation to various national several patent offices and national courts. The second abuse was regarding the submission of the request for deregistration of the marketing authorization of Losec capsules in Denmark, Sweden and Norway. And not only deregistration of the Losec capsules, but also the launch of Losec MUPS tablet, means that is a new kind of the new form of the tablet where it is known as the multiple unit pellet system, system of tablets where multiple microgranules were released at a time. So, it has tried to take out or take away all the existing Losec capsules from the market and introduce the new tablet. So, the basic intention for this was to prevent the parallel importers from supplying the same Losec capsules. So, all these actions taken together, the commission found that it is a kind of abuse of dominant position and it is violating the article 102 as well. So, the appellants like the AstraZeneca's strategic implementation of the regulatory framework in order to artificially protect from the competition products that were no longer protected by a patent and for which the data exclusivity has expired, this condition has been taken into task by European Commission. And with respect of these two abuses, the commission imposed a fine of nearly 46 million euros on AstraZeneca AB and separate fine of 14 millions also. So, so far these are the major cases which has led to the incorporation of the guideline regarding to the settlement agreement or pay for delay practice in the technology guidelines on the technology transfer agreements. So, one of the other important thing in this guideline is the guideline regarding the technology pools and the restraints. So, as you know, the TTBER applies to the licensing agreements concluded between the pool and the third party licensees. So, in making those kind of assessment, the commission is generally guided by the three main principles. First, it is of the belief that the stronger the market position of the pool and the greater will be the risk of anti-competitive effect. Second, the pools that hold a strong position on the market should be open and non-discriminatory. Third, the pools should not unduly foreclose third party technologies or limit the creation of the alternative pools. So in assessing the technology pools, the commission assesses the position of the market, position of the pool, what kind of technologies it is incorporating, and how it is dealing with the third party technologies. So one of the kind of technology pools are the patent pools. So basically, patent pools can give the companies the cheaper and easier access to the necessary intellectual property rights, such as the standard essential patents, or like it is a kind of one stop shop for the intellectual property licenses. So by recognizing the often pro competitive nature of the patent pools, the creation and the licensing from the patent pools benefit is generally given benefit in the safe harbor guideline, because like it is a kind of arrangement where easily one can easily get many technologies at a go. So it is generally given a safe harbor position in the guideline. However, the commission also lists a number of factors which will be considered when it assesses whether a patent pool can generally benefit from the safe harbor or not. Like it looks into whether the participation is open for all or not, like is there any restriction for entry of these firms or parties to those kind of the pool. Second, it also looks into what kind of safeguards are in place to ensure that only essential technologies are pooled. You know, this technology area is very complicated. So, like these wireless communication or ICT or the latest technologies, it's very difficult to assess like what is essential and what is non-essential. So, unless there is a strict scrutiny that the patent pool consists of only essential patents, then it becomes difficult, because you end up paying more for the less number of technology. So, always there should be safeguards to ensure that only essential technologies are pooled. Third, the pooled technologies are licensed into the pool on a non-exclusive basis. So, the non-exclusivity of these pooled technologies are also essential factor in determining the nature, like whether it can get a safe harbor or not. Then the pooled technology is licensed out of the pool on FRAND terms, like the fair, reasonable and non-discriminatory terms. So, which we will discuss later on in the later segments. And the parties contributing to the technology to the pool and the licensee are free to challenge the validity and the essentiality of the pool technology. So, there should be like no challenge clause associated with this kind of pool, and the parties contributing to the technology to the pool and the licensee are free to develop competing technology. So, not only they can use the technology, but they should be free to develop further technology by using those kind of thing. So, these are there are safeguards against the exchange of sensitive information also. So, these are the few criteria which the European Commission looks before giving a safe harbor provision to this kind of agreement. So, so far we discussed all about this technology transfer block exemption regulation and the safe harbor provisions, how the European Commission has looked into the technology transfer agreement involving various intellectual property rights, and not only like safe harbor for the defined kind of agreements, but what is the scope for the agreements which falls outside of the TTBER. So, in the later modules we will discuss about the standard essential patents, like in intellectual property the essential patents, like how the technology has defined standard essential patents. So, all this will be discussed in the later segment. So, thank you.